What if I told you that most vehicle repossessions are unlawful and you can challenge them using laws that dealerships and lenders hope you never learn? Now, in this video, I'll break down step-by-step legal process to fight back against repossessions, get compensated, and possibly reclaim your vehicle or walk away debt-free. Now, I've studied consumer law, repossession statutes, and contract enforcement, and I'm here to help you stop getting bullied by the system. You dig me? Now, before we dive into this video, make sure to hit the like button. Make sure to subscribe to the channel. We want to be at the top of the algorithm so that people can actually see this information. A lot of questions are out there, and a lot of people are in situations where no matter what you do, they will still try to repossess your vehicle, whether you do it the right way, so you think, or whether you are, attempting to apply any of the strategies that I teach. But we're going to talk about the whole aspect of how most repossessions are not legally performed. We're going to talk about the aspect of knowing your protections and your rights under the Constitution. And we're going to talk about how you can do it in a powerful way administratively so that you can be able to hold companies accountable when they unlawfully repossess your vehicle. All right. So also, before we dive into that, make sure to know that this is not legal advice. This is not financial advice. Do not employ these strategies if you are not going to do your due diligence. You dig me? And I'm talking to you, right? That person is going to watch this video all the way to the end and not do their due diligence, maybe hear everything I say, and it won't be clear, but you'll still just try to do the steps and then end up in a situation where they're going to get your vehicle, end up in a situation where you'll lose, and then you'll come back and say, well, Nicholas told me to do this. No, I'm telling you that I'm giving you a baseline as best as I can, but you have to empower yourself to go gather the knowledge on your own. All right. Knowledge is power. So don't shortcut it. You dig me? All right. So let's dive straight in. Make sure you stay all the way to the end. You dig me? Because we're going to be talking about things that nobody is talking about. Now, let's dive into how most repossessions are not legally performed. Okay. The first step is many lenders violate contract, the UCC, or even state laws when repossessing. So what they'll do is they'll skip over due process and fail to provide proper notice. Okay. Most people don't know is before they repossess the vehicle, you're supposed to be notified of the repossession. It's not a case where, oh, you just don't know your car is about to be repossessed. And they'll do things like maybe they'll send you collection letters, and maybe they'll say, hey, we're going to take legal action for this, right? But if they never state that, hey, somebody's coming to repossess your vehicle in the next 14 or 30 days, here's your opportunity, right, to maybe even pay, maybe even dispute it, or whatever the case may be. If they don't provide this, they're already moving unlawfully. You understand me? And then most people don't realize that they have a right to challenge repossessions. And it's not in a way of you challenging whether or not they should take your vehicle or not, but you're challenging based off of the debt. Because when you are challenging a repossession, the repossession conversation is about the debts, because they're saying that you owe. So because they're saying that you owe, if you fall behind on those promises, then what happens is they feel like they have the right to take possession over or after you have defaulted. Now, other states are different, so make sure you're looking at your state laws. There's some states that they don't have to go through a court system in order to repossess your vehicle. Some states they're not required to notify you, but they must at least take you through the administrative process and let you know that there is a debt that needs to be paid before they repossess. We're going to talk about all that today. Now, repossession isn't legal just because they showed up with the tow truck. Okay. There are so many elements of a repossession or processes that they must take in order for them to actually take your vehicle. Okay. Just because they tell you over the phone, we're going to take your vehicle. Well, okay, bet you do the full due process before you take my vehicle. And in that due process, I'll have many opportunities to cure whatever it is or even dispute it. If it's something where it's just out of the blue and I didn't even know I was going to get repossessed, that right there is illegal in itself. Okay. And then we can even talk about the aspect of breach of peace. We can talk about the aspect of, their dishonor when you challenge debt and things in that nature. But let's just continue and talk a little bit about the UCC. Okay. Now, let's just talk about the legal protections that you have. First thing I want to go to is UCC 9-609. Under UCC 9-609, it talks a little bit about secure parties' right to take possession after defaults. Okay. After defaults, a secure party may take possession of the collateral and without removal may render equipment unusable and dispose of collateral on the debtor's premises under 9-610. Okay. It also talks about how there's a judicial and a non-judicial process. A secure party may proceed under subsection A pursuant to judicial process or without judicial processes if it proceeds without breach of peace. Okay. It says the assembly of collateral. If so agreed, in any event after default, a secure party may require the debtor to assemble the collateral and make it available to the secure party at a place to be designated by the secure party, which is reasonably convenient to both parties. And then one of the things that they do is they kind of take your vehicle almost 50 miles away from where your premises is. So you can easily argue that they are not making it convenient. But I want to pull up the definition of secure party. Okay, because you see that a lot. So I want to just see what they have specific to what their definition of secure party is. Let's go back one. I don't know why when I click this it's not pulling up. Let's in UCC law, a secure party is a person or entity whose favor a security interest is created and provided under a security agreement. This can be a lender, seller, or anyone who holds interest in the collateral as a result of a transaction. Okay. The secure party's role is to protect their investment in a loan or transaction through collateral. So you can yes, by all means, you can have the conversation and say, okay, bet if you are looking at it from a perspective that they lent you money, then yes, by all means, they are the secure party. But what if I told you they wasn't? What if I told you that they're only a secure party and we're going to talk about this, if the contract, one, has proper consideration. They're only a secure party if they've actually loaned you money to buy the vehicle. They're only a secure party if that promissory note wasn't securitized. And there's also a code under UCC 3-305. Under UCC 3-305, there's the aspect of the holder in due course in your defenses against someone who isn't the holder in due course under UCC 3-305. You dig me? So it even talks about the aspect of you signing something under duress, lack of legal capacity, illegality of the transaction, right? Nullifies the obligation of the obligor. Fraud induced the obligor to sign the instrument with neither knowledge nor reasonable opportunity to learn of its character. So one of the things is, okay, bet if I apply for something, you should for sure notify me and tell me exactly what it is that I should be, what is happening behind the scenes, no matter what. Okay, let's go back on the uniform code. Let's go to negotiable instruments. Let's go to holder in due course in their definition. Okay, so the holder in due course means the holder of an instrument if the instrument, when issued or negotiated to the holder, does not bear such apparent evidence of forgery or alteration, or is not otherwise so irregular or incomplete as to call into question of its authenticity. You dig me? The holder took the instrument for value in good faith without notice that the instrument is overdue or has been dishonored, or that there is a uncured default with respect to the payment of another instrument issued as part of the same series, without notice that the instrument contains an unauthorized signature or has been altered, without notice of any claim to the instrument described under section 3-306, and without notice that any party has a defense or claim in recoupment described in section 3-305, that's defenses and claims. Okay, it says notice of discharge of a party other than discharging in insolvency proceedings is not notice of a defense under subsection, but discharge is effective against a person who became a holder in due course with notice of discharge. Public filing or recording of a document does not of itself constitutes notice of defense, claim in recoupment, or claims to the instrument. Okay. So, okay, here we go. Let's talk about this too. Except in extent to a transferor or predecessor in interest has rights as a holder in due course. A person does not acquire rights of a holder in due course of an instrument taken by legal process or by purchase in an execution, bankruptcy, or creditor sale or similar proceedings. Okay, or by purchase as part of a bulk transaction and not in ordinary course of business of the transferor as the successor in interest to an estate to other organization. Okay, and it continues and continues and continues, but I don't want to go, but it's so many great things that it's talking about specifically under what is a holder in due course. Holder in due course is the person that has the security interest, but if it doesn't meet these guidelines, this person can't be the holder in due course. Okay, so some of the things that we understand is that we can easily argue that there's evidence of forgery or alteration. Okay, we can argue that there's irregular or incomplete that makes whatever they're saying that something is owed to them or they are ownership of the vehicle. That technically is something that we can easily call into question given effect under the contract principles. Okay, but let's just go back real quick to so when you think secure party, this secure party is a holder in due course, and they must be a holder in due course in order to be a secure party, just to bring it back to this. And someone may say, okay, well, the bank is a secure party, but you can easily question their security interest on a vehicle or a loan or instrument. Okay, because if they sold it, then they lost the holder in due course title. Okay, so this is part of the things that they violate. They won't tell you that they're not. There are steps that they take that they have lost their security interest. So technically, they don't have a right to take possession after defaults, no matter what. The only reason they do it is because our inaction and not responding to them directly is what kind of allows them to do what it is that they want to do. Because when you don't respond back, you actually acquiesce. Okay, when you acquiesce, you agree unknowingly. Okay, so let's dive into the FDCPA. The FDCPA is one of the strong suits to challenging or really stopping a repossession, because if a company says that you owe them X amount of dollars, then one of the things that you want to do is you want to send them a debt validation letter. Once you send a debt validation letter, they must dispute the debt or allow you to dispute and provide that documentary evidence before they repossess the vehicle. It's no, I will ignore you for 2 or 3 months or a year, and then I'm going to repossess the vehicle because time passes. But it's more in the aspect of they have a duty to validate the debt when you ask for the validation of the debt. You understand me? So here's the thing, okay? Under the FDCPA, it says that if a third-party collector is involved, then it could potentially be harassment, deception, misrepresentation. It could potentially mislead you, okay? It could potentially be a violation of them acquiring your location information without your consent. It could potentially be an unfair practice, okay? And they'll be under civil liability if they collect in any form or fashion that violates your rights under the Fair Debt Collection Practices Act. So you have protection under the FDCPA. Many protections as soon as you send that debt validation, even though you have it there, but you sending that debt validation letter is you asserting your rights. And now they have to start providing some answers to you. Now they must perform to you. But one will say, okay, bet, well, what am I supposed to do if somebody tries to repossess my vehicle? I always tell them a simple answer, debt validation letter. And they say, okay, well, what do I do with that? What do I do after? Read the law. It tells you right there. Okay? It says that under the FDCPA, if you send them a letter and they ignore you, then you want to make sure to send them another letter. Okay? And that's also under the UCC, talking about evidence of dishonor too, under UCC 3-505. Now let's just talk about contract law, because this is probably the easiest way to really start to challenge the debt itself. One of the things that they'll do when you're challenging the debt, okay, they will not give, well, before we do that, one of the things that they will do is they don't follow contract law on the original contract itself. Okay, under the original contract itself, they're not following the They're not following the foundations of contract law. So when you look at the foundations of contract law, number one, there's offer and acceptance. When you send an offer, okay, there must be an acceptance or refusal. So even when you send a debt validation letter, in some way, shape, or form, that's an offer, okay? An offer to perform if they do X, Y, and Z, okay? So you can either accept it or reject it. That's part of a contract. You create a contract when you send them a letter, but they also created a contract where they have given you an offer and you accepted it by signing the agreement. But the offer was that, hey, we're going to loan you X amount of dollars so that you can get this vehicle. And this is where things get a little fishy when we talk about the aspect of consideration. It says each party must provide something of value in exchange for the other party's promise or performance. This can be money, goods, services, or a promise. So number one, your promise is the consideration in this case, okay? As a debtor or as a creditor, you are the one who is moving in honor by giving your promise, okay? But the part that they don't tell you is that they take your promise and they get the money from the promise. And they never actually exchange anything with you. They just take your promise to create the money and they give you something that you technically created. So you can easily argue that, number one, you are not even moving. There's no real lawful consideration as it pertains to this transaction. Okay. So under contract law, we can even talk about the aspect of intention to create legal relations. We could talk about capacity. Parties must have legal capacity to enter into a contract, meaning they are of age, of sound mind, and not otherwise disqualified. Legality, the purpose and performance of the contract must be lawful and not violate public policy. And the terms of the agreement, under certainty of terms. The terms of the agreement must be clear and definite, allowing the court to determine the party's obligation. Okay? Yeah. So someone said, okay, well, I was under the impression that the car was a gift. And yes, in that element, a car is the gift or really the distraction. You dig me? Because in a consumer credit transaction, they're supposed to give you money in hand. Okay. And what they do is they deposit money in your account. If I bring up the definition of deposit, you dig me? Deposit, Cornell law. I think that's under 1812 USC 1813. You know what? 12 CFR 204. When you look at the definition of deposit, it says deposit means the unpaid balance of money or its equivalent received. I think the key thing that we want to understand is the unpaid balance of money. So when they put a deposit in your account, they're literally saying that they owe you something. So instead, they have you focused on the car and not what they actually owe you. So yeah, in essence, right? They're not actually giving you the money, and it says it right here under 12 CFR 204.2, the definition section, okay? Which is the code of federal regulations. You understand me? Under Title 12. You get what I'm saying? So when it comes to contract law, they must follow exact terms of notice, grace period, and defaults. Now, if they don't do this, here's some questions that you want to ask to make sure that they are adhering to this. And they must answer these questions under contract law, under the FDCP, and under the holder in due course, under the UCC. This is where they violate your rights. When you ask them these questions and they decide to ignore it, then they are violating their rights. And whatever you ask them will determine whether or not they are moving in honor or not. So one of the questions you can ask is, hey, did they give proper notice of default? Meaning, did you take me through an administrative process? Did you send me a letter at least 3 times notifying me of what could happen or when the default happened? Okay, not an email, not a phone call. Did you send me mail? Because the process doesn't start until they start sending you mail. When they send you mail, a lot of people mess up by ignoring the mail themselves, not knowing this puts you in an even worse position. But if I receive a letter from a debt collector about repossessing my vehicle, I'm going to send them a letter back immediately. Okay? So this is why I need proper notice of default. The second thing is, hey, did they break into the garage or threaten you? Okay, so this right here is when they start to threaten you, I'm gonna garnish your wages, or I'm gonna do this, that, and the third if you don't give us the vehicle. That right there is a clear violation of the Fair Debt Collection Practices Act. Okay, that's also a clear violation of the breach of peace. So one of the things is, okay, bet when you look at the breach of peace, oh man, the breach of peace really breaks down some stuff too. Under breach of peace, and notice how I look up all of this stuff here. Okay. I look up all of this stuff on Google so that you can particularly see that anybody can look this stuff up. Part of me talking about this is so that you can, be aware of these things, because a lot of times one of the things that are mess us up is not that the information is out there. It's just that we don't know where to look. We don't know what to even, they're not teaching us this regularly, right? You right now can easily be able to find out how to do the Pythagorean theorem. You would know to look that up because they taught you that in school. But what if they just taught you about being able to overcome repossessions, being able to overcome a debt collector in school? Then when you got out of school, you'll actually look up those concepts on your own. So let's look at the aspect of breach of peace. Breach of peace refers to a criminal offense that disturbs the public peace or order. Okay? It's often used as a general term for disorderly conduct, encompasses a wide range of behaviors that disrupt the tranquility of the community. Okay, so let me do this real quick. Repossessions, breach of peace real quick. Breach of peace in the context of vehicle repossessions means the repossession process violates public order or tranquility, often involving physical force, threats, or actions that can provoke violence. It essentially means repossession is conducted in a way that goes against the law and could lead to a disturbance of peace. So, what constitutes a breach of peace? Physical force, threatening to use force, entering a locked garage without permission, ignoring verbal objections from the vehicle owner. So if they're coming to repossess your vehicle, if you tell them not to and they ignore it, that's considered a breach of peace. So when you see these videos of people fighting repossessors, they're not supposed to get to a point where they're escalating it to that point. If a person says, do not touch my car or I'm gonna smack you, they need to back up. Okay, don't, as the repossessor, don't put yourself in harm's way to take the vehicle just because you want to prove something. You're not even the holder in due course. I don't care who gave you the right to do this. You're a separate entity. You're a separate company. Okay, a repo man entering a home to retrieve a vehicle parked in the garage without permission, using violence or intimidation to force someone to sign a repossession agreement, physically removing the vehicle while the owner is inside. Okay, so when you see videos of people literally getting in their car, they must put the car down. Okay, violence or threats. Okay, trespassing, entering restricted areas without permission, like a closed garage or a locked property. Okay, harassment, engaging in persistent or abusive communication or behavior aimed at intimidating the borrower, taking the vehicle over protest, continuing repossession after the borrower has clearly and unequivocally objected. You're not the law, repossessor. If I tell you no to not take my vehicle, you haven't even seen the letters that I've sent to the company for you to feel like you are within your right to take the vehicle. You dig me? So here's the thing, right? Object. That's why they try to do it all discreet. Okay, lifting an occupied vehicle, towing the vehicle while someone's inside, potentially endangering their safety, property damage, damaging the borrower's property beyond what is necessary for repossession. Okay, why is breach of peace illegal? Violation of the UCC, dig me? Violation of state laws, violation of consumer rights. What are the consequences? Civil liability, criminal charges, and loss of right to a deficiency judgment. Okay. It even says, okay, this is what you want to do. You want to document the incident. You want to take photos or videos. If something like that is happening, then record it. You want to seek legal advice. I always tell people, even after I teach you, seek that legal advice. And then consider legal action. Okay? So, yes, if this happens, take them to the task. All right? So, the thing is, if they didn't follow the rules, you may be owed compensation. So yes, you may get your vehicle taken, but if it does, I would tell one to not give up, but to start challenging them directly. Hold them accountable. Take them to court if you need to. You feel me? Now, let's talk about the administrative power move that I would do. Okay, I'm not at all telling you to do this and not giving you legal advice. If you got this far, 26 minutes in, go ahead and hit the subscribe button. Go ahead and hit the like button. Thank y'all down below. We doing this live on Twitch, so I see you guys in the chat. Jody, Mike, Cheese, 52 Sav. I see y'all in the chat. If you haven't tapped in with my Twitch, the link will be in the description. You dig me? Now, let's just talk about the steps that you want to take if you get into a position where you have to now challenge the debt collector. Okay, so first things first is when they send you that debt validation letter, one of the things that when they send you a debt letter, you want to first take them through conditional acceptance and debt validation. You want to demand that validation and conditional acceptance under 15 U.S.C. 1692G. Okay. Some of the things that you can ask under conditional acceptance is, hey, I hereby conditionally accept your presentment and claims upon receipt of the following if give me a certified copy of the original signed agreement bearing my wet ink signature, if you can give me proof of lawful consideration exchanged at the inception of the agreement. Lawful consideration is the aspect of, okay, did you actually exchange something with me lawfully? I need the full chain of assignment from the original creditor to your office, and I need a full accounting and ledger under UCC 9-210 showing all debits, credit, discharges, and insurance payouts. That's not limited to what you have paid or what you have not paid. It's also unlimited aspect of, okay, was there discharges? Was there insurance payouts for this debt? Okay. Proof that no third party, issuer, government, or bond has been satisfied to offset this obligation, such as a 1099-C, and invalid proof that your office is the holder in due course under UCC 3-301. You dig me? Absent of full compliance, your claim will be deemed unsubstantiated and no legal or moral obligation shall exist. You understand me? Now, this is my letter on the notice of tender. You can also add like an affidavit of truth where you're pretty much just breaking down the things that you know as regards to, and you can probably pause and take a look at that. But just for time's sakes, you can add an affidavit of truth. It's not necessarily needed, but it does help and really make your argument much stronger. Okay. You can demand debt validation under 15 U.S.C. 1692G. Debt validation is specifically, as a matter of fact, I can pull that up real quick. Debt validation. Go back one. Debt validation really kind of just is the same format as conditional acceptance. Okay. You can really put it hand in hand with the conditional acceptance. I'm writing in response to your recent communication regarding the alleged debt referenced above. I do not acknowledge this debt and am demanding full validation and proof of claim. Under 15 U.S.C. 1692G, 15 U.S.C. 1601, UCC 3-301, and UCC 3-302. We talk about UCC 9-210. We talk about UCC 3-305. And please provide the following documentation: a copy of the original signed promissory note, proof that you're a person entitled to enforce the instrument, a complete accounting ledger of all debits, credits, and charge-offs, a full chain of assignment and custody, IRS forms 1099-C or 1099-A if the debt was sold, discharged, or canceled, proof of lawful consideration, confirmation of any securitization or sale of the note. Okay? Until this request is fully complied with, this debt is disputed, not validated. Any further collection activity, including reporting to credit bureaus, may be considered a violation of federal law. I reserve my rights under UCC 3-1-308. This letter is a good faith effort to resolve the matter lawfully and honorably. Okay? So you can do this. You can send this as the debtor. You can let them know that you are not the debtor, that you are a secured party. You're an authorized representative of the debtor, or you can do it straight through your trust. You understand me? So that's what a debt validation letter, conditional acceptance, they all kind of look the exact same. It's just the wording and how you would change it. Then if they don't respond, you want to send them a notice of fault and defaults, essentially saying, hey, look, my baby, this is what I asked for in my previous letters. Because you ignored me or you decided to keep trying to collect, maybe you missed what I sent you 30 days ago, but I'm sending it to you again to give you an opportunity to cure your fault. Okay, so you give them that opportunity to cure. After the opportunity to cure, if they continue to try to collect and ignore or just not respond, then you have them default, because you've already tried to repossess my vehicle. You already tried to make an attack on me, try to harm me. And all I'm doing is moving in good faith and asking you some questions that you should answer, my baby. So boom, if we get to the point that you default, now you're the one that gets repossessed, and not in the sense where you're going to repossess the vehicle because the vehicle is already yours. But if you're in a position of where now they have defaulted, just like they can take your property for defaulting, you can pretty much sue them for defaulting too. So if they don't respond, then you dive into the notice of intent to sue or tort claim. So part of this is challenging directly and then making sure that they have they are being sued not for them trying to repossess, but now they're being sued for violating your rights. This is how you play offense. And now you could stop at the default and you could use this against them as evidence if they try to repossess your vehicle. But it's best if you kind of start taking action and you move on offensive, okay? So, but you need to make sure you are, if you do send them an intent to sue, don't just do it as a threat. Actually intend to sue them. Don't send an intent to sue and then don't sue them, okay? So if you're not going to sue them, then maybe you just hold this as evidence. But try to communicate. Don't let things go, time pass, and then they come and take your vehicle, and now you are stuck with no vehicle. You got to pay to get your vehicle out. Now you got to sue them for the money that you just paid. Okay. So the next thing is you want to file a bond claim against their insurance. Okay. And the last thing is understand that they are operating in commerce. Okay. So you use the commerce to make them liable. Now, here's what to do if they decide to sell your car. Okay. Number one, you want to demand proof of sale and itemization of proceeds. Okay. So one of the things that you want to make sure of is after they sell it, you want to make sure to know exactly what they sold it for, how much money they made, so that you can be able to get your piece, because technically it's your piece. Okay. They sold it without real or proper jurisdiction. The second thing you want to do is you want to challenge any deficiency balance. Did they sell it commercial? Did they sell it under a reasonably? Okay. If they didn't, that's also something that you want to make sure of. The third thing, repossession must be in good faith and in line with UCC 9-610. If they aren't the secure party, then they should not have repossessed the vehicle. Okay. And then lastly, you want to file small claims or civil complaint if the repossession was unlawful. So you can sue for wrongful repossessions, okay, even after the car is gone. So don't give up. When you start to challenge the debt collector or when they repossess your vehicle, it doesn't have to end there. This is when you start to do that work. Don't message me and say, oh, they repossessed my vehicle. What do I do? This is why you kind of want to do the action now. If you feel like your car is about to be repossessed, you know. So start doing the due diligence now. I hope you're watching this video before it happens. If you know that you're not going to make your payments, then start doing the due diligence before those letters come. Okay? Because they'll come fast. All right? Now, building your paper trail, you want to make sure to send your letter certified. Okay? You want to keep all records of notices, correspondences, and violations. If you're talking to me, right, I speak to people a lot about, oh, I did this and I did that. And I say, okay, bet, what have you sent them? What have they sent you? And they don't know. Oh, I got to go find it. See, you're not taking responsibility or accountability. If you truly want this to happen, you was just hoping I was going to get on the phone and tell you some magic lotion or potion or some pill that you can possibly take, and then you're going to get your vehicle back, or you're going to absolutely know. At least do the thing that you could do is by gathering enough evidence as possible, especially before you come to me, okay? Or before you go to a lawyer or any type of attorney for this legal help. Don't just go to them and just say, hey, what do I do now? What do I do this? And they've already repossessed your vehicle. That's going to take too much time to learn and get prepared for, all right? And if they don't reply, move to a lien or take them to court, okay? Their non-response is a violation within itself. Okay, so you want to use affidavits, you want to use UCC notices, and you want to use conditional acceptance to create a legal record of you challenging the debt, disputing, and giving them an opportunity to shift that burden of proof onto them and provide you proof in order for them to repossess. You can have my car if you can prove X, Y, and Z. And if you give them that opportunity and they don't really capitalize on that, then they already knew that they lost. So understand that your paper trail is more powerful than their assumptions. I don't care what you can assume or tell me, whatever the case may be, I got you beat. So now that we got all the way to the end, if your car has been repossessed without proof, notice, or peace, they might be in violation of multiple laws, okay? And trust me, you don't have to accept it, okay? Yes, if it happens, it happens. And you feel like, okay, bet, well, yes, boom, my car's gone, whatever the case may be. But if you don't want to accept it, you want to be able to do it, make sure you learn the system and make sure you fight back. Don't just stop at learning. Learn and take action on what you learn. If you decide not to take action, take responsibility. Dig me? Because you can also speak to the aspect of, okay, bet, like if you did get a vehicle, and let's just say you are in the aspect of you bought a vehicle that you couldn't afford, that you couldn't make payments on, and if you defaulted, it was more of either you got something that you couldn't afford, and it was more of you not doing your due diligence to make sure that that wouldn't happen. And it is more of you just either you're spending your money on something else instead of paying or taking care of your responsibilities. Okay? It doesn't matter how you look at it. You still have to take accountability and still be responsible for your actions. If you decide not to pay something, make sure you know how to challenge it. If you decide not to pay something, make sure you understand that, hey, you decided to buy or pay for something else instead of paying for that. Don't get mad at them for doing what they've been doing to you for the last 10, 20, maybe even 30 years for some people, maybe 40, 50 years. Okay, don't get mad, okay? Use this as an opportunity to learn. Things don't happen to you, they happen for you. So if that car got repossessed, just like me, when my car got repossessed, that woke me up. That made me start taking action. That made me start actually learning and sitting down and spending the time every single day to learn how to communicate with debt collectors so that didn't happen. I didn't get mad at them. I got mad at myself. And I took that energy and I transmuted that into learning the knowledge. I took that energy and used it against them. Okay? I used it to be able to, in a positive way, whether it's to take my experience and be able to tell you guys how to be able to overcome these experiences, or whether to take my experience and be able to challenge them myself and never have to go through that again. And also at the same time, be able to help my family, okay? So again, there's nothing wrong with paying your debts. There's nothing wrong with discharging debts. There's nothing wrong with communicating with debt collectors, sending a couple letters. There's nothing wrong with paying, okay? It's just the energy thing. Whatever takes, I won't say the least amount of energy, whatever values your energy the most, then do that. Some people just have what, a $200 car note and they make $20,000 a month. I mean, that's only what, 10%? I could be wrong. 10% of your income, 2% of your income. So if it's 2, or let's just do the math. What's boom, it's all right. You make $20,000 a month and you spend $200 on a car note, that's literally only 1% of your energy. So it's nothing wrong with paying debts or whatever the case may be if your life looks like that, okay? Maybe you don't have to spend a lot of time learning all the legal jargon and all that to be able to discharge debt for the rest of your life. That's why part of me teaching you this is to segue into teach you how to grow a business and develop a lifestyle to the point where, yeah, the concepts you don't always have to know and having to put yourself in a situation where you got to challenge every debt collector. Okay? Maybe start a business. Okay? Maybe use your time wisely to invest in yourself and grow. All right? So for all my debt people, tap into the Complete Debt Guide down below. The Complete Debt Guide will have a repossession response toolkit. Tap in with that. You become an affiliate once you become a Complete Debt Guide member. Number 2, if you want to work with me one-on-one, you want to start a business online, you want to be able to get funding or fix your credit, tap into that one-on-one mentorship. It's only for people that want to do those things, okay? And obviously people who do work with me one-on-one, they can ask me questions about consumer law. But if that's all you want as a mentorship, then just tap into the live, tap into my Twitch, tap into my YouTube lives, and we're going to keep it going from there. And make sure to follow me on Instagram too at biz.nick. I'm going to be dropping my stream clips. I'm going to be dropping more game, me just maneuvering through life, you able to see my lifestyle, connect with me, but more importantly, tap in so that we can be connected on a more personal space. All right. And lastly, make sure to tap into the Twitch, man. We're going crazy on there. Just became affiliate. Remember to drop a comment if you or someone you know got their car taken without a fair fight. Remember to like, subscribe, turn on the post notifications, man. I love y'all. Let's get to it and never let them play you again. If you got all the way to the end, comment the word discharge, and I'll see you in the next one. Ha!